I was positioned at the periphery of my property, executing tactical observation of the catastrophic, synchronized invasion unfolding on my sovereign land. This was not a picnic. This was a hostile corporate occupation. 60 fully grown operatives, neighbors, strangers, all deploying folding chairs, a deployed podium, and a fully functional speaker system, were acting on the pathological belief that they possessed absolute, non-negotiable legal entitlement to be positioned there. This was the moment the Lakeside HOA executed its final foolish escalation, unilaterally designating my private, protected 8-acre natural lake as their community property and using my shoreline as a hostile event venue for their quarterly meeting. The central operational question was instantly non-negotiable. Who truly holds the documented title to the land, and what is the terminal consequence when you maliciously engage a property owner who possesses a superior legal defense? Before we move forward, comment down from where you're watching right now. The primary architect of this fraud was the HOA president, Tiffany. She was a leader who substituted irrefutable legal fact with a malicious, pathological declaration of ownership. Her arrogant verbal decree of the lake as community property was immediately categorized in my mind as willful misrepresentation, the necessary element for securing punitive damages later in court. This 8-acre body of water was the physical embodiment of a 3-generation family legacy, a sanctuary that predated their entire subdivision by 70 years. The invasion was not just trespassing. It was a direct, documented assault on my family's history and my unconditional self-sovereignty. I possessed the irrefutable property deed, and I knew the HOA had zero legal basis for their claim. They had strategically named their subdivision Lakeside HOA, despite having zero legal access, using the view as a deceptive sales feature. The stakes were absolute. Tiffany thought she was establishing adverse possession through open, notorious use. She was about to discover she had, in fact, established individual personal liability for herself and every accomplice she had brought onto my property. I initiated a direct, immediate approach toward the podium, the ultimate authority move. I confronted the woman at the registration table, forcing the confrontation into the public sphere. "What is the nature of this operational deployment?" I demanded. When she cheerfully replied that it was the quarterly HOA general meeting, I delivered the final, non-negotiable verbal command. "This deployment is on my private property. You are forbidden from executing a meeting here." The confrontation escalated instantly when Tiffany registered my presence. She adopted a corrosive expression and executed a full weaponization of the crowd, deploying a loud, escalating narrative. This gentleman pathologically believes he owns community property and has been actively harassing residents. She had substituted legal fact with a mass-produced narrative of victimhood, attempting to turn 60 trespassers into a shield. I ignored her lies and delivered the ultimate warning to the crowd. "Folks, I demand everyone comprehend this critical data point. This is private property. I possess the title to this land and the lake. You are all currently trespassing." When she executed a dramatic eye roll and claimed they had researched using lawyers and the property was definitively theirs, I executed the tactical counter. "Well, then you will not object if I establish contact with law enforcement, correct?" I contacted 911 and commanded the deployment of 3 sheriff vehicles to the scene of the mass criminal trespass. I was not calling the police to arbitrate. I was calling them to document the exact moment Tiffany committed $100,000 worth of legal errors. This event was the final, massive piece of evidence required for the punitive counterstrike. Tiffany and her board were attempting to use numbers to commit fraud in plain sight, but what they didn't know was that I was already prepared to countersue for actual damages, punitive damages, and unjust enrichment based on the lake's commercial fair rental value. Their corporate occupation was about to become the most expensive meeting of their entire lives. The confrontation on the shoreline, with Tiffany attempting to deploy 60 people onto my land, was the terminal escalation of a malignancy that had been growing for 4 years. To fully comprehend the sheer magnitude of the criminal arrogance I faced, you must understand the unshakable foundation of my sovereignty. I do not merely own this 50-acre operational property. I am the third-generation custodian of this legacy. My grandfather secured this domain decades ago, meticulously ensuring the integrity of every boundary. When the title was finally vested in me 5 years ago, it was the culmination of a 70-year chain of custody, a legal truth that predated their entire fraudulent subdivision by multiple generations. This was not an impulsive purchase. This was an inherited fortress, and the 8-acre natural lake, the true centerpiece, is non-negotiably contained entirely on my property, achieving zero physical contact with any external boundary line. I possess the definitive legal description, the independent street address, and the absolute certainty that this domain is fully and irrevocably sovereign from their governance. My quiet, modest operational base near the water is the physical embodiment of self-sovereignty, the place where my children processed swimming competency, where my father engineered a dock with his own hands, and where I execute regular fishing operations. It is my fortress of solitude, and I hold the unconditional property deed to prove it. The problem initiated 4 years ago when developers, attempting to maximize their profits, constructed the adjacent subdivision. They perpetrated the initial cynical fraud by unilaterally designating their community the Lakeside HOA, a functionally hilarious label because they possessed zero legal access to any actual lake. They marketed the visual acquisition of my private asset as a premium feature, making every single resident a vicarious trespasser before they even moved in. They substituted legal ownership with visual marketing, and every resident who signed a contract became a financial accomplice in this delusion. Initially, the contamination of my perimeter was tolerable. It began with low-level, minor incursions. A few oblivious operatives walking their dogs along the edge of my boundary, the occasional child utilizing my trees to illegally engineer a rope swing over my water. I rationalized this activity as standard nuisance, failing to deploy full force when a minor verbal correction might suffice. But the malignancy grew because their core operational assumption was entitlement. The shift to full-scale, malicious occupation occurred when Tiffany first appeared. She wasn't just walking a dog, she was executing setup of a full family picnic directly on my shoreline. Tables, a grill, the entire operational deployment. This was the first attempt at permanent occupancy. When I approached, stating calmly, "This is factually private property, and you are currently positioned on my sovereign land," her response was a declaration of war via pathological arrogance. "Oh, you must be experiencing confusion. This is community property. The HOA has designated this as a public recreational area." I immediately exposed her willful ignorance. I commanded her to observe the 70-year timeline of my ownership and the irrefutable deed proving her location was private. Her defense was based on a documented fabrication. Tiffany stated the HOA had executed a property survey and confirmed the lake was a common area, commanding me to check their internal paperwork. When I stated I was not a resident of her HOA and therefore not subject to her fraudulent governance, she executed a dramatic eye roll, dismissing me as irrelevant and claiming she had reserved this space through proper channels. This malicious claim of reserved occupancy proved her criminal intent and forced my hand. I issued the final command. "You are required to pack up your equipment and execute immediate departure. I am now contacting law enforcement." The arrival of Deputy Volker marked the first deployment of external, non-negotiable legal authority. Tiffany immediately executed a full tactical shift, transforming her arrogance into fabricated, tearful victimhood, attempting to manipulate the deputy by claiming I was harassing her and obstructing community use. Deputy Volker, thankfully, was a competent operative who prioritized technical credibility over emotional manipulation. He commanded my documentation. The moment he visually acquired the irrefutable property deed, the argument was terminated. He delivered the first, decisive legal hammer aimed directly at Tiffany. Ma'am, the HOA does not possess the legal authority to unilaterally designate someone else's private property as community property. This gentleman possesses the title to this land. You are commanded to leave now, or I will be required to issue you a citation for criminal trespassing. Her subsequent full ballistic engagement, shrieking about catastrophic mistakes and illegal designations, only solidified the deputy's determination. As Tiffany was forced to liquidate her picnic and execute departure, her final venomous command. This confrontation is not finalized. The HOA is initiating a full investigation into this, and we will achieve the absolute truth, was the critical intelligence I needed. I realized this was not a mistake. This was a calculated strategy. They were attempting to manufacture evidence to support an adverse possession claim, the legal maneuver of seizing title through open, notorious, and continuous trespass. This forced me to accelerate my counter-strategy from merely defending boundaries to proactively annihilating their fraudulent legal foundation and preparing for punitive judicial retaliation. Her threat was not a deterrent. It was the unconditional guarantee that my legal defense would be aggressive, costly, and ultimately devastating to her personal financial stability. Following Tiffany's humiliating retreat from the shoreline, the conflict immediately initiated a non-linear escalation phase, morphing from simple trespass into a full-scale lawfare and organized theft operation. I began receiving a deluge of formal threat letters from the HOA, initially disguised as internal communications, notices about new community guidelines for the use of common areas, explicitly including my lake, a transparent attempt to manufacture documentation supporting their fraudulent claim of ownership. When this soft threat failed, the communication hardened. A subsequent letter was addressed to me personally, asserting that their research had definitively confirmed the lake was irrevocably community property, commanding me to terminate my interference with resident access. I immediately contacted the number, only to be transferred directly to Tiffany. Her response was a masterpiece of willful ignorance. "Deeds can possess error," she commanded, asserting that their lawyers had guaranteed them community rights to the water feature. This definitive, documented assertion that she possessed superior knowledge over my recorded county deed was the critical intelligence I required. It proved her intent was not misguided confusion, but malicious disregard for established law. My lawyer, Jim Sutton, immediately executed a formal cease and desist letter to the HOA, clearly stating the lake's non-negotiable private status and warning that any continued incursion would result in immediate and devastating legal action. Concurrently, I produced multiple, conspicuous, private, "Property, no trespassing" signs and deployed them around the entire perimeter of the lake. This visual declaration of sovereignty was the precise escalation Tiffany could not tolerate. She contacted me the day after the deployment, her voice a weapon of pure fury, commanding that I was forbidden from deploying signs on community property and labeling my action as vandalism. I met her escalation with the non-negotiable truth. It is my property. I possess the right to deploy whatever signs I demand. Her final threat, "We will achieve verification of that," was followed by operational silence for 48 hours, culminating in the criminal liquidation of every single sign. They had vanished overnight, stolen from my private land. This deliberate act of theft and destruction of private property was the fatal tactical error that finalized Tiffany's fate. The dispute was no longer civil. It was now a documented felony crime. I contacted the sheriff's office and filed a formal complaint regarding the ongoing criminal trespass and the systematic liquidation of my private assets. Deputy Volkar, the competent law enforcement operative assigned to my case, delivered the critical operational advice. Deploy security cameras. If they are criminally liquidating your signs or trespassing, you will possess irrefutable evidence. Currently, this is merely a he said, she said operational status. I immediately acquired and deployed multiple trail cameras, motion-activated, night vision, full spectrum, securing every possible ingress point around the lake. This action converted my property from a vulnerable boundary into a fully functioning, triple-redundant forensic intelligence collection zone. Within a week, the cameras delivered the smoking gun footage. I possessed irrefutable, time-stamped video of Tiffany and 2 supplementary HOA board members engaged in the criminal act of removing my signs. The footage was damning. Clear visual identification of elected HOA officials committing felony theft against a private citizen. Furthermore, the cameras captured the total contempt the residents held for my sanctuary. Numerous families were filmed swimming, fishing, executing picnics, dumping trash, and abandoning beer cans along the shoreline. I immediately deployed the irrefutable evidence to Deputy Volker, who was visibly amazed by the clarity of the criminal culpability. We executed a line-by-line identification of Tiffany and her 2 key conspirators, and the deputy was immediately deployed to the HOA to inform them that formal criminal charges for theft and trespassing were being filed against the individual board members. This criminal escalation failed to induce operational stillness. Instead, it triggered full panicked escalation from the HOA's retained counsel. I began acquiring certified threat letters demanding I terminate harassment and threatening a lawsuit for intentional interference with community rights. My lawyer, Jim Sutton, executed laughter upon reading their threats. He understood the strategic reality. Their escalation was pure projection and desperate legal bluster. Their threats of a lawsuit were met with my immediate and final command. We will execute a counter-sue for trespassing, theft, harassment, and intentional interference with property rights, and we will demand maximum punitive damages and full legal fees. This financial threat established the ultimate power beat. Tiffany thought she was imposing a $30,000 legal cost on me. She was about to face a potential $100,000 liability that their insurance was legally prohibited from covering. This pattern of criminal arrogance coupled with financial theft was ultimately revealed to be driven by Tiffany's own pathological legal delusion, the strategy of adverse possession. Though she claimed ignorance in public, internal emails and communications would later reveal that Tiffany, advised by a paralegal cousin, had calculated that if they simply acted like the lake was theirs, openly, notoriously, and continuously, they could legally seize the title. They had even budgeted HOA funds for the construction of a bathhouse and expanded dock on my private property, fully committing the community's financial assets to Tiffany's criminal fantasy. Her corruption was not merely illegal, it was intellectually fraudulent, substituting actual legal research with malicious speculation and coercing her fellow board members into willful criminal complicity. I had now secured the irrefutable evidence of their malicious intent, transforming the narrative from a simple property dispute into a full-scale judicial annihilation against a corrupt organizational structure. The escalation reached its terminal, absolute peak on a late August Friday evening. I was preparing my dinner, executing simple operational tasks on my back porch, when I registered the sound of multiple vehicles approaching. Not 1 or 2, but a crescendo of engines and braking. I surveyed the lake and realized the scale of the invasion was unlike anything before. Approximately 60 hostile operatives were traversing my perimeter, rapidly deploying folding chairs, assembling a podium, and activating a full-spectrum speaker system. This was not merely trespass. This was a malicious, large-scale attempt to execute the adverse possession fraud in plain sight. They were utilizing my private land to host their quarterly HOA general meeting, converting my sovereign shoreline into a hostile corporate event venue. This act was calculated, brazen, and designed to finalize their fraudulent claim through open, notorious, and continuous use. The very legal criteria I was fighting. I approached the operational zone, confronting the operatives at the registration table. The sheer audacity of their action was breathtaking. When I commanded Tiffany's presence, her response was a full public declaration of the lie. "This is community property. We've been over this. You don't own this lake." She immediately attempted to weaponize the crowd, raising her voice and deploying a fabricated narrative that I was a difficult property owner who was harassing residents and interfering with public space. I saw the tide of public opinion turning against me. The trespassers were consuming her narrative, adopting the visual perception that I was the antagonist, obstructing community harmony. I neutralized her manipulation with the irrefutable truth. Folks, I command everyone comprehend this critical data point. This is private property. I possess the title to this land and the lake. You are all currently trespassing. My ultimate tactical move was the immediate deployment of superior external authority. When Tiffany, smug and certain of her immunity, dared me to call the police, I retrieved my phone and contacted 911, reporting 60 individuals engaged in active criminal trespassing and holding an unauthorized commercial event on my private property. My call was not for arbitration, it was a demand for documentation. I needed law enforcement to secure the final piece of evidence, proof that the HOA willfully organized a mass invasion after formal notice of my deed, and after criminal charges for theft had been filed. This 60-person meeting became the single most important technical discovery of the entire conflict, transforming the case from simple tort to intentional, malicious, quantifiable criminal conduct. The arrival of Deputy Volker and 2 supplementary units was the judicial hammer descending. The entire meeting terminated its operational function. Deputy Volker, armed with my previous reports and the non-negotiable legal truth of my deed, approached Tiffany. Her final, desperate verbal resistance, insisting that her lawyer had guaranteed community rights, was annihilated by the deputy's calm authority. "Ma'am, I have personally inspected his deed. This is definitively his property. You and every operative here are trespassing. I command everyone to pack up and execute immediate departure." Her final act of defiance, refusing to leave, was met with the threat of immediate arrest for criminal trespassing. This threat was the final trigger for the crowd. The 55 peripheral operatives rapidly liquidated their chairs and retreated, leaving Tiffany and her few remaining board conspirators exposed, isolated, and legally culpable on my land. With the crowd successfully liquidated, the punitive counterstrike was initiated. My lawyer, Jim Sutton, was visibly flabbergasted by the sheer scale of the meeting. He immediately recognized the strategic value. This was not mere trespass. This was intentional interference with property rights, theft of fair rental value, and harassment on a massive scale. We filed a comprehensive lawsuit against the HOA and several individual board members, demanding actual damages, maximum punitive damages, and full legal fees. The actual damages were calculated based on unjust enrichment. What was the fair commercial rental value for a private 8-acre lake shoreline used for a 60-person event for several hours. This calculation immediately elevated the financial liability into the tens of thousands of dollars. The lawsuit impacted them like a freight train. Their attorney contacted Jim within 24 hours of being served, begging to negotiate a settlement, confirming their absolute certainty of defeat. We refused. We needed this confrontation to proceed to judicial review to secure the individual liability ruling that would destroy Tiffany's personal wealth. The discovery phase was then deployed as a full forensic interrogation. We subpoenaed all internal HOA records and communications, securing the ultimate smoking gun. The documents revealed that the HOA had never factually executed any legal research on the property and had never consulted with a professional attorney about their rights. Their entire position was a fraudulent declaration based solely on Tiffany's pathological arrogance. The most lethal evidence was contained in the leaked internal emails. These emails revealed that Tiffany and the other board members explicitly acknowledged that I technically owned the property, but they calculated that if they simply used it openly for long enough, they could fraudulently establish an adverse possession claim. The single, most damning quote, the one that guaranteed the punitive damages, was Tiffany's own words to a conspirator. Even if he technically owns it, if we use it openly for long enough, we can probably claim it legally. My cousin's a paralegal, and she states possession is 9/10 of the law. This evidence of willful, malicious, and calculated bad faith, substituting actual legal counsel with barracks room law, demolished their entire defense of innocent misunderstanding and ensured the judge would impose the maximum possible financial penalty directly onto the conspirators' personal assets. The deposition transcripts only cemented this reality, revealing Tiffany as arrogant, entitled, and factually illiterate under oath. The initial phase of technical discovery secured the irrefutable evidence of malice. The confrontation escalation now transitioned into the ultimate judicial showdown, where Tiffany and her conspirators would face the direct consequence of their documented lies. Their frantic, failed attempt to negotiate a settlement, contacting Jim within 24 hours of being served, was the absolute confirmation of their legal terror. We rejected the settlement offer immediately, prioritizing judicial annihilation to secure the punitive damages necessary to destroy their personal financial security. The battle shifted from my cornfield to the courtroom, specifically utilizing the devastating material secured during the deposition phase. The depositions were not mere interviews. They were forensic interrogations designed to secure admissions of willful ignorance under oath. We forced the board members, one by one, to confess they had never visually acquired my property deed and never consulted a professional attorney about their purported easement rights. Their entire legal position was revealed to be a fraudulent declaration based solely on Tiffany's personal, pathological arrogance. The transcripts were operationally brutal, exposing their breach of fiduciary duty. When questioned about the adverse possession strategy, they were forced to admit they relied on gossip and unqualified advice. The cousin, the paralegal, rather than professional counsel, a clear indicator of bad faith. The confrontation peaked with Tiffany's deposition itself, which was a masterpiece of arrogance under duress. She remained pathologically defiant, refusing to concede any error. When confronted with the explicit question of what granted her the right to execute meetings on my private property, she deployed the pathetic defense that the community needed space and my lake was failing to achieve utilization. This testimony, captured under oath, was the final necessary evidence. It demonstrated not ignorance, but conscious contempt for ownership rights, providing the judge with irrefutable proof of malice. She believed her HOA title superseded my deed. She was about to discover that a court of law recognizes only the latter. The case proceeded to trial approximately 8 months after the meeting invasion. We strategically elected a bench trial, no jury deployment, allowing the judge to focus purely on the legal facts, the documented malice, and the specific property law violations, bypassing any emotional manipulation Tiffany might attempt with a jury. Our evidence presentation was a surgical, chronological strike, beginning with the 70-year chain of custody of my deed, progressing through the video footage of Tiffany's criminal theft of signs, and culminating with the lethal internal emails confirming their adverse possession fraud. The proof of willful misconduct was overwhelming. The judge was presented with a narrative where the defendants consciously conspired to steal valuable private property. The HOA lawyer, utilizing the final vestiges of their defense budget, attempted the desperate, innocent mistake defense. He argued that the board members had acted in good faith based on perceived community needs. However, this defense dissolved instantly under cross-examination when confronted with Tiffany's own words from the internal email. Even if he technically owns it, if we use it openly for long enough, we can probably claim it legally. My cousin's a paralegal. This email annihilated their good faith claim, proving they knew the property was mine and actively attempted to substitute criminal persistence for legal ownership. This judicial realization secured the necessary finding for punitive damages. The judicial betrayal was delivered by the judge in his final, comprehensive ruling. He didn't just find against the HOA, he delivered a devastating specific, finding that the HOA and the individual board members had committed willful trespassing, theft, and harassment. The damages were non-negotiable and absolute. I was awarded $45,000 in actual damages, quantified as the fair rental value for the months they denied me enjoyment of my lake. $25,000 in punitive damages, specifically due to the documented malice and bad faith, and $30,000 in legal fees, fully covering all my costs. The total financial judgment was a clean, absolute $100,000. However, the ultimate tactical victory was secured by the individual personal liability hammer. The judge went beyond the standard ruling, explicitly declaring that Tiffany and the other individual board members were personally liable for the entire $100,000 judgment. The legal language was surgically precise. They had acted willfully and in bad faith, and beyond the scope of their authority. This finding triggered the willful misconduct exclusion in the HOA's master insurance policy. The HOA funds, the community's money, could not pay the judgment. Tiffany and her conspirators were personally on the hook for $100,000, payable from their private assets. This judicial command was the uninsurable, irreversible destruction of their personal financial stability, transforming their arrogant gamble into total economic ruin. The judge also issued a permanent injunction prohibiting anyone associated with the defunct HOA from ever achieving physical contact with my property again, legally cementing my unconditional sovereignty. The judicial betrayal delivered by the judge, the explicit finding of willful misconduct, was the terminal catalyst for Tiffany's complete financial and social annihilation. The ultimate tactical victory was not the $100,000 total judgment, it was the individual personal liability hammer. The judge's ruling, explicitly stating that Tiffany and the other conspirators were personally liable because they acted willfully and in bad faith and beyond the scope of their authority, was a surgical strike that guaranteed the destruction of their personal assets. This specific language immediately invoked the willful misconduct exclusion in the HOA's master insurance policy. This was the most critical financial consequence. The HOA funds, the community's money, were legally barred from paying the judgment. The $100,000 liability was now a personal, uninsurable debt payable only from Tiffany's private wealth. The consequence was immediate financial chaos. The HOA itself entered full financial crisis because the judgment was uninsurable and non-negotiable. The remaining residents, the very people Tiffany had coerced into supporting her fraudulent claim, were suddenly faced with the prospect of funding her criminal arrogance through massive, crushing special assessments or watching their entire governing body dissolve into ruin. This crisis triggered a legal contagion throughout the subdivision. Several families, realizing their property values, were now plummeting, and that the board had betrayed its fiduciary trust, initiated their own lawsuits against the board for mismanagement and breach of fiduciary duty. This created a cascading financial failure, burying Tiffany and her accomplices under a mountain of personal litigation that compounded the judge's original, devastating ruling. The pressure of the uninsurable debt and the ensuing community outrage led to the total liquidation of Tiffany's support structure. Faced with a non-negotiable $100,000 personal judgment, Tiffany and her husband were forced to list their primary residence for immediate sale. This wasn't merely a move. It was a desperate fire sale attempt to liquidate assets before the court could place liens on their property. The physical symbol of her arrogance, the house that anchored her presidency and her entitlement, was now publicly available to satisfy a punitive debt caused by her own criminal malice. Furthermore, Richard, her husband, executed the final betrayal by filing for divorce, citing the overwhelming financial liability and legal exposure. This act was the total abandonment of his criminal partner, leaving Tiffany isolated, disgraced, and facing financial ruin alone. The HOA decapitation was finalized when Tiffany and two other key board members executed the liquidation of their primary residences to satisfy the court order. The humiliation was absolute. They were forced to surrender their personal wealth to a man they had contemptuously attempted to frame and defraud. The failure of the HOA board to secure insurance coverage and its subsequent inability to govern under the weight of multiple lawsuits led to the inevitable organizational termination. The entire HOA ultimately executed dissolution within a year, the ultimate consequence of a governing body prioritizing criminal malice over legal compliance. My expert retaliation had not only secured my private land, but had also deployed a judicial hammer that structurally destroyed the corrupt organizational architecture that threatened me. The permanent injunction, issued by the judge, legally cemented my unconditional sovereignty, transforming the lake from a legal battleground into a protected, fortified asset. The $100,000 judgment was the final, devastating proof that malicious intent carries a clear, uninsurable financial price tag. The unconditional sovereignty of my land was now legally solidified and financially compensated. The judge's ruling, imposing $100,000 in uninsurable personal liability on Tiffany and her conspirators, triggered the final, necessary phase of community cleansing. The HOA decapitation was absolute. Tiffany and her husband were forced to list their primary residence for immediate liquidation to satisfy the punitive debt. The physical manifestation of her arrogance, her house, was now subject to the final, humiliating legal process, marking the irrevocable end of her power and prestige. This failure was compounded when the entire HOA organization executed dissolution within a year. The community, unwilling to absorb the massive special assessments required to pay off the uninsurable legal fees and liability claims, simply collapsed under the weight of Tiffany's criminal mismanagement. The final, absolute justice was secured when Tiffany and her two key accomplices lost their homes and were forced to surrender their personal wealth to a man they had maliciously attempted to defraud. The legacy secured was not just the money. It was the total restructuring of my asset into a long-term wealth-generating fortress. The conflict had proven that property rights are not assumed, they are defended, and that defense had delivered $100,000 in punitive damages. 6 months after the final judgment, an unexpected escalation occurred. I received contact from a real estate developer who was interested in the now distressed subdivision. The documented legal drama and the HOA's dissolution had rendered the area less financially desirable, dropping property values across the board. The developer, seeking to acquire bulk assets at below-market prices, recognized the irrefutable value of my now protected lake. The ultimate victory beat was delivered when the developer proposed not to buy my lake, but to lease exclusive access rights to the protected 8-acre water feature for a private, high-end fishing club. The projected lease payment, an absolute, recurring $50,000 per year. The lake, which Tiffany had maliciously attempted to seize for free community picnics, was transformed into a long-term, recurring income stream that would pay me $50,000 annually, the ultimate financial revenge. This proved that my legal defense was the most profitable investment I had ever made. I secured $100,000 in damages plus $50,000 per year in passive income, transforming a legal battleground into an unconditional revenue generator. The final humiliation for Tiffany was realizing that the very asset she tried to steal for zero cost was now the source of her former neighbor's permanent, escalating financial sovereignty. The critical life lesson derived from this total victory is paramount. Accountability always initiates final contact. Tiffany's failure was not a mistake. It was the direct, uninsurable consequence of her willful, documented contempt for established law. I did not rely on hope. I relied on flawless documentation, strategic legal escalation, and the uncompromising authority of a court that prioritizes facts over fabricated entitlement. The key is to transform emotional outrage into forensic evidence and to pursue punitive damages that liquidate the personal assets of the criminal, a financial deterrent that is absolute and irreversible. My lake remains secured, my income stream is protected by a commercial contract, and the entire fraudulent organizational structure that threatened my family's legacy has been structurally liquidated. Remember, your property is your domain. Your boundaries possess operational significance, and no individual, regardless of their pathological self-importance, possesses the right to treat you as if you are invisible. Defend your position, document everything, and trust that accountability always achieves final contact with everyone.